Welcome, everyone, and good evening. Thank you so much for joining us this evening. It is really fantastic to see old friends outside of Zoom boxes and new allies alike tonight. My name is Keith Tyrion. I'm very proud to be the interim co-president of Alliance for Justice alongside Betsy Miller-Kittredge. But we wouldn't be here tonight without the support of our dear friend and AFJ board member, Deepak Gupta, and his firm, Gupta Wessler. Thank you once again for hosting us on this amazing rooftop this evening. We're also pleased that Deepak will be serving as our moderator for tonight's discussion. I also want to thank specifically Abigail Roston for handling the logistics at the firm for this evening. And an event like this and the work that Alliance for Justice does is only possible with the strong team that we have in place. So first, Lizzie, who you've heard from this evening, for leading the charge this evening. I also want to welcome Paulette Meyer, our board chair. A warm welcome to our founder, Nan Aaron. And again, because it takes a full team, if everyone representing either the staff or the board can raise your hands. Tonight also wouldn't be possible without the generosity of our event sponsors, SEIU, Bernstein, Leidowitz, Berger, and Grossman, Outen and Golden, and Labaton, Keller, and Sasharo. As many of you know, Alliance for Justice is an association of nearly 140 organizations committed to building power, transforming courts, and securing justice for all. For 45 years, AFJ has been fighting for a more fair, just, and diverse federal judiciary and state courts, while empowering nonprofits and member organizations to maximize their advocacy capacity while staying within the compliance restrictions on nonprofits. Holding the Supreme Court to a higher standard, or frankly, to any standard at all, is central to our work over these years and has become increasingly important as it's become increasingly salient, not only to progressives, but everyone across the country. We're coming together this evening only one day after the court convened its 2024 to 2025 term. It promises to bring more significant decisions that impact every issue that touches our lives, even as we continue to reel from the damage of the recent terms behind us. We know that this court, once they secured a supermajority of justices, has turned back the clock on our rights and the very concept of justice. Rivaling the Lochner court in its overreach, they've attacked everything from reproductive rights to gun violence prevention to the very balance of power, all while engaging in flagrantly unethical behavior. To cover this, we're thrilled to be joined this evening with speakers with such expertise on the court and the issues at stake this term. MSNBC's Ari Melber will be joining us, the nation's Elie Mystal, Brady President Kris Brown, and award-winning transgender journalist Erin Reed. We already know that several cases on the docket, and even more awaiting cert, stand to harm our real way of life. And even more that we're tracking will threaten more issues that we care about. These include the very safety of transgender youth, an opportunity to gut even the most common sense of gun violence prevention measures, upend environmental and administrative law, and yet another attempt to impose Christian nationalism on our society. But our Holding Court series isn't just for the experts to talk to you. We want to hear from you. Many of you on your seats have note cards and pens that throughout the program you can write questions you have for the speakers, and including others that were submitted during registration. We'll be adding those into the Q&A at the end. Before I turn it over to Deepak, a quick reminder that Alliance for Justice is a 501c3 organization, and as such, despite the upcoming election, we will not be honing in on those issues this evening. We will leave that to our 501c4 Alliance for Justice Action Campaign. If you don't know what I'm talking about or have questions about your own organization, many of our Boulder advocacy attorneys are on hand to answer those questions and provide you resources. On to our program. To introduce Deepak a little bit, our moderator is the founding principal of Gupta Wessler. His practice focuses on the Supreme Court, appellate and complex litigation on behalf of plaintiffs and public interest clients. He's also a lecturer at Harvard Law School, where he teaches the Harvard Supreme Court Litigation Clinic and seminars on forced arbitration, the civil justice system, and public interest entrepreneurship. So again, thank you all for being here. I'm very much looking forward to hearing from Deepak and our speakers, and enjoy this evening.
Thank you all for being here, and welcome to our rooftop on this beautiful fall evening. I again want to thank my assistant, Abigail Roston, for all the incredible work she did in helping put this together. As Keith mentioned, our firm is called Gupta Wessler. We handle cases in the Supreme Court on behalf of plaintiffs and public interest clients. We have 3 cases in the Supreme Court this term. We had 3 cases in the Supreme Court last term. And as a result, I need to make a disclaimer of my own, which is that our firm doesn't necessarily endorse any of the things that are said here. In fact, you probably definitely don't endorse much of what you're about to hear. I'm going to try to keep my opinions to myself as much as possible and turn things over mostly to our esteemed panelists. And I've been doing a lot of Supreme Court preview events lately, and they're more staid affairs. There's practicing lawyers and law professors, and they're kind of going one by the cases and telling people what the case is about. But what I'm excited about tonight is I think it's going to be something very different, where we have journalists, we have the head of an advocacy organization, we have an outspoken columnist, and soon we'll be joined, I hope, by an MSNBC host. And that's a range of perspectives that you don't get on the conventional kind of Supreme Court preview, and I think it'll be more interesting, I hope. There's a lot to talk about. Last term, we had a term where the court expanded presidential immunity and effected a massive power grab from administrative agencies to the judiciary on how to write rules about health and safety. I guess I do have some opinions. This morning, we had a lively debate about ghost guns. We'll hear about how that went. And tomorrow, the court is going to hear a big death penalty case. So there is a lot going on for a term that's been described as sleepy. So let me quickly introduce our awesome panel. To my left, I'm joined by Erin Reed, who I just met tonight, but we had a great conversation. Erin is an award-winning transgender journalist based here in DC. She tracks LGBTQ plus legislation around the United States for her subscription newsletter, erininthemorning.com. So make sure you sign up. I'm glad to have you here tonight, Erin.
Thank you so much.
And next, I'm joined by Elie Mystal, who probably doesn't need an introduction in this room, but Elie is the nation's justice correspondent. He's the host of its legal podcast, Contempt of Court. And this you may not know, Elie has a new book coming up, which will be published in March 25, is that right? Called Bad Law, 10 Popular Laws That Are Ruining America. And Elie was a guest on a previous holding court, so welcome back, Elie.
Thank you so much. I have thoughts that I do not have to keep to myself, so looking forward to that.
And next we've got Kris Brown. Kris is the president of Brady, which works to free America from gun violence. And we're really pleased that you found time to join us today on a big day for guns in America. Kris has a lifelong background in policy law and grassroots activism, and she started her career on Capitol Hill working for Representative Jim Moran, advocating for the bill that would eventually become the groundbreaking Brady bill. So thanks a lot for joining us.
Thank you for having me. Pleasure to be here.
And I'm going to just introduce Ari. I think he's currently taping his show, or on his way here, or something like that. But he doesn't really need an introduction either, but because he has an MSNBC every night. But what you may not know is, in addition to hosting that show, he's MSNBC's chief legal correspondent, an NBC News legal analyst, and a lawyer himself. So hopefully Ari will jump in and join us as we move forward. I want to start by talking about the ghost guns case, Kris, because this just happened today, and the other panelists, of course, should jump in. But this was a case about the federal government's regulation of ghost guns, which this is a pretty scary thing. I didn't know about this until this case came up, but that these are kits that you can download anonymously on the internet, and within minutes, you can create a gun that is operable, and these things are being used in crime. So what did we see this morning? What what were the arguments before the court, and what's your take on how this is going to go?
Well, I'll just give a news flash that the arguments went very well for those of us who care about saving lives from gun violence, preventable gun violence. So that's a nice news flash for this court. And for those of you who may not be familiar with ghost guns, thank you for that introduction. But they're kits that are basically available online, and you can buy the kits. They're delivered to your home, and you can assemble a fully functioning firearm, in some cases within a minute, literally. I thought the part of the brief that was most interesting, hello? Hello, we're sharing a mic, is when you can get the kit and assemble the firearm literally in a minute, and it's easier than putting together the easiest chair that you could buy from IKEA. This is intended and in fact marketed to circumvent gun laws. And there are companies that have been in business now for 4 or 5 years. Brady helped put one out of business, by the way, Polymer 80. That was manufacturing these kits and selling them literally in one of the kits that was put into the government's brief. They had a picture where these are unserialized, by the way. If you're a federally licensed firearms dealer and you are selling a firearm under the Gun Control Act, then you have to put a serial number on it. That's the law, that's the rule. This is designed, as I said, to circumvent the rule. These kits are unserialized. So if you are a police officer recovering one of these firearms assembled in minutes, there is no way to determine where the gun was sold, how it was sold. This is essential for solving crimes. Some of these guns were sold where the serial number would go. It literally had a middle finger pointing at you, which is what was pointing at the police officer when they recovered these guns in crime, saying, this is where the serial number would have been. So that's what was before the court today, and I would like to claim it as a huge victory because I think just the precursor is Chief Justice Roberts, Amy Coney Barrett, even Justice Kavanaugh, raised a lot of issues with the arguments that this ATF rule issued in 2022 could be anything but constitutional, but it was an administrative law case. The Second Amendment never came up in this case. And the reason why is because the rule that was issued as a result of, issued by the ATF after President Biden at the gun violence prevention movement's urging said, please have ATF issue a rule banning ghost guns. And they did in 2022. That's the rule at issue. But it was issued pursuant to the Gun Control Act of 1968 that said, anytime a gun is sold in the United States, it should be through a federally licensed firearms dealer, and it should be subject to a background check. And the way that that rule was designed, it clearly anticipated and Congress wanted ATF to regulate not only firearms sold in 1968, but others that could be sold that could circumvent the rule. That seems pretty straightforward. And that the ATF has been doing that really for 50 years. So we're really pleased with the way the questions were posed, with the answers. For the folks who were trying to say that this rule should be overturned, which is what the Fifth Circuit did, by the way. They overturned this rule, right? It was somewhat humorous, let me just say that, I suppose, to listen to the lawyer squirm who was trying to explain, well, really, this is necessary for hobbyists. And that's why. And hobbyists have a long tenured, long agreed Second Amendment right to build guns at home. So then the justices started getting into what might have happened in homes in 1789. And it didn't go well from there. So we feel pretty good about where we are.
Can I just underscore something really quickly
please.
about the case? It's that, to be clear, when ATF promulgated the rule, it didn't ban ghost guns. It just said that ghost guns had to have a serial number, and if you sold them, you had to have a background check, just like any other gun. And when they passed this rule, the market for ghost guns collapsed. And that should tell you something, right? The fact that as soon as you had to have a serial number, as soon as you had to pass a background check, the market for these guns absolutely collapsed. And it actually came up an argument today made by Elizabeth Prelogger. By the way, if you haven't heard Prelogger argue, like, you haven't listened to Carmen in French. I mean, like, you have not been to the Sistine Chapel, right? Like, you haven't seen it as well as it can be done. But it came up when Prelogger was like, well, why? Because the question was, well, why do people want these guns at all? As you say, the ghost gun lawyer was like, for hobbies. And Prelogger was like, for crime. The reason why these guns sell is for crime. And so I think, like you said, I think there were at least a couple of Republican justices who heard that argument today.
Yeah, she really was fantastic. I got a chance to listen to the argument. I'm curious if either of you have thoughts, or anyone of the panelists. Last term, we had a case about a different ATF rule about bump stocks, and the court invalidated that rule. And one way of looking at this case when it came to the court is, oh, it looks pretty similar. Same agency, also a regulation about guns, arguments about administrative overreach, statutory interpretation arguments, and yet it seems like this is going to go very differently. Why?
Yeah, I absolutely thought that this case would go down just like Cargill, the bump stock case. But I think that it went differently because you can still get a ghost gun, right? The bump stock ban was an actual ban. You could not legally obtain bump stocks anymore. Whereas with the ghost guns, you could still legally obtain a ghost gun as long as it had a serial number, as long as you passed a background check. So it wasn't a complete ban on the product. And I think that's slightly what changed it. Also, I just think that the equity is involved here. I mean, like, it ended up sounding a lot more like, and tell me if I'm wrong, but it ended up sounding a lot more like the Rahimi argument from last term, where the court kind of just on basic criminal justice lines ruled that, kind of upheld a law keeping domestic abusers from owning firearms just because the equities involved are so kind of obviously dangerous. And so it ended up sounding more like the Rahimi argument than like the Cargill argument, which is what I think the difference was.
Welcome, Ari. I pre-introduced you, and thanks so much for joining us and coming right over from taping your show. So I want to jump right into what I think is indisputably the blockbuster case of the term. And if you read some of the newspaper previews, it's been described as a very sleepy term. Not if you're somebody who cares about the rights of transgender people. This is not a sleepy term. It's a very important term. And so, Erin, I want to ask you about this case that concerns a transphobic Tennessee law that bans gender-affirming care for minors. The plaintiffs are 3 Tennesseans and their parents. They're challenging the law on equal protection grounds. And interestingly, the court granted a petition by the Solicitor General, Prelogger. This law would require individuals that are currently undergoing treatment to abandon their medically advised healthcare regimens. And over 20 other states have similar laws on the books. That signals a new front, I think, in culture wars in this country over this kind of treatment. And what we're talking about here is a situation where you've got a potentially suicidal teenager whose parents think that they need this treatment, they think they need the treatment, the doctor thinks they need the treatment, and the state is stepping in and saying, you can't do that. So tell us what's really, in your view, at stake in this case, both in the particular case, but then broaden it out. And you and I had a chance to chat a little earlier, and I think you have a really interesting perspective on this.
Yeah, thank you. So let me just preface to sort of set the picture here. Over the last 3 years, there have been 1,200 bills targeting the trans community across the United States. They target trans people in every aspect of our lives. We see bills banning medical care for trans youth, but we also see bills banning bathroom usage. If I use the same bathroom in the state of Florida that I use today here, I could be put in jail for up to a year, a male jail for that record. We see bills targeting driver's licenses and your ability to change your gender and even your name on your driver's license in the state of Texas right now. We see bills targeting everything from education to sports to teachers. We've seen trans teachers fired in a number of states. And so We then get to where we are today. Many of the healthcare bans, the bans on gender-affirming care for transgender youth that have passed across the United States, they are blunt force instruments. They don't allow for any sort of doctor determination. They don't allow for any exceptions whatsoever for transgender people. And this is the same care that many cisgender youth are receiving for things like precocious puberty or other medical needs, that they are given the exact same treatment that the trans youth are being given, but they're now being denied in those states. So we have this case in Tennessee that has finally reached the Supreme Court. And what the Supreme Court determines is going to determine the future for our community in the next 10 to 20 years, probably. The Supreme Court's going to be deciding, for instance, on due process rights for transgender people. And in fact, we have an argument right now that is in the Supreme Court that, you know, the parents of trans youth are saying that they've got the right to provide medical care for their youth, and then the state and the Sixth Circuit Court, which had previously heard the case, is basically using the Dobbs decision and using Geduldig to state that, oh, well, this transgender care is not deeply rooted in this nation's history and traditions, and so therefore it should be banned.
In fact, we were just talking about it. The state's brief was filed this afternoon, and it cites Dobbs 10 times.
It does. Dobbs is heavily implicated with anti-trans legislation, by the way. But, you know, if you try to say that the only medical care that you have a constitutional protection to is the medical care that was present in 1850, then suddenly heroin for coughs is constitutionally protected, but cancer treatments aren't. And that's kind of what we're seeing with this kind of legislation. And then, bigger than that is they're going to determine if transgender people have equal protection under the law. If we are implicated in sex-based discrimination, if we're implicated in suspects' class status, and the determinations that they make will not just affect transgender care, for instance. If they say that we don't have equal protection under the law for transgender healthcare, then it could lead to bathroom bans. It could lead to every bill that you could possibly pass against a trans person being considered legal. There are people that want to institutionalize trans people, legislators that want to do that, for instance. And it doesn't only affect trans people, because these same rulings can then be turned on things like, for instance, birth control, saying that they don't have enough evidence for birth control under the age of 18. And in fact, one potential application is to COVID vaccines, for instance. We have seen in the state of Florida, which has led the attack on transgender healthcare, the leader of the Florida Department of Health has basically advised all the doctors to no longer provide mRNA COVID vaccines. It's one small step for a governor to say, pseudoscience basically shows that this anti-vax stuff is right, and so vaccines or COVID vaccines are banned in my state. And they can use the same exact rationale to do so. So this has huge implications for my particular community and the one that I report for.
And just to underscore something that Erin said, like, understand that this is a straight up kind of point and click equal protection violation. As Erin mentioned, if you are a cisgender boy, if you're born a boy, you can take a testosterone booster. Right? You're undersized, you want to play the football, and you can take a testosterone booster and get on the field. Medically safe, with your parents' consent, you're all good, right? But if you're born a girl, if the state of Tennessee assigns girl to you at birth, you can't take the same medication. That is a straight up equal protection problem. That is like a woman walking into a bar in Tennessee and being like, I'd like a beer. And the bartender going, well, we don't like to serve beer to little ladies, but I can make you a delightful lemon spritzer. Like, what the hell is that? Like, that's not what you asked for, right? Serve the woman a beer. Serve the people the medical treatment that their doctors have agreed to and their parents support. Because the other thing that's going on here, when we talk about the hypocrisy of these people, let's not also forget that a lot of times these people say, oh, it's actually about parental rights. You shouldn't be able to be trans without having to tell your parent and beg your parent. Well, this is a case where the parents want the children to receive the medical treatments that would be available to them if they were born assigned a different gender at birth. That's all this is. And I do think it's going to go horrible in front of this Supreme Court. But it's such a basic violation of the Equal Protection Clause that if this goes bad, Erin's right. Like, what happens next is almost unimaginable.
And I actually want to jump in real quick to piggyback off of that, in that the way that the Sixth Circuit Court got around the equal protection claim is they said, oh, well, gender transition treatments are banned for everybody equally. And I want to remind everybody that this is the same rationale that was used to defend gay marriage bans. Basically saying, oh, well, everybody has the right to marry the opposite sex. Doesn't affect gay, like it will not affect straight people, it will only affect gay people. And so we see a very similar rationale.
So, this case doesn't fit the pattern in some ways, that usually there's a big divisive issue like this, and it percolates in the lower courts for years, and the Supreme Court doesn't take it, sometimes for decades. And in this case, the court reached out and sort of grabbed the issue, including the issue of equal protection classification, almost at the earliest possible opportunity. And I'm curious, like Elie, if you or others, does it seem like a conservative grant, like an attempt to kind of grab the issue early and say that there is no suspect?
Yeah, so one of my favorite headlines about the current court situation comes from The Onion. And the headline was simply, "The Supreme Court, we wear gold crowns now." We live in what we've termed a juristocracy, right? We live under the power of 9 unelected, unaccountable judges that have a veto power over the elected branches of government and every state government. The most important branch is the third branch, is the federal judiciary, because they can stop anything they want. They can, as Deepak said, reach out into any state, into any law, and be like, oh, we'd like to rule on that now. We don't want to let the states decide. We don't want to let the voters decide. We want to do that for ourselves right now. And the way, if you didn't believe me before this summer, you have to believe me now after their decision in Chevron. Now, Ari's here. I know he doesn't like me to say the word Chevron out loud. But in this audience, I think I can get away with it. The Loper-Bright, the Chevron case, involved the repeal of a foundational judicial doctrine called Chevron deference that involved the courts giving deference to the executive agencies on matters of their expertise, right? It was kind of simple. It was the thought that, well, judges are not experts, the agencies are experts, and they should have the final say in determining what Congress meant when it wrote the Clean Air Act or the Clean Water Act or any number of regulations. Now, if you talk to non-lawyers, if you talk to people who haven't kind of been in this world, they were like, a lot of them will say, well, what's wrong with that? Shouldn't Congress decide, not the executive agent? It's Congress that writes the laws, not these executive agencies. And you understand where that comes from, because these people haven't thought about things as simple as, well, define water for me, Jimbo. Oh, it's so easy to define. Well, the water that the EPA can regulate, is that a puddle? Is that the ocean? Is that a lake? Is that groundwater? Define water, sir. And they can't. It's actually a really difficult question, right? So now the question becomes, who gets to decide what water is, right? Is it Congress? Is it the experts at the EPA? Or is it Neil Gorsuch? And Neil Gorsuch says, no, it's totally me, dude. No, I totally got this. I'm the only one in the world that can define what water is, because I am a Supreme Court justice and you are not. And that is the core of Loper-Bright from last term. That is the core of getting rid of Chevron deference. It is the court saying that it, and only it, can make these critical decisions about what laws actually mean, right? Now, we're in DC, so I assume many of you have met a congressperson. Do we really think that the Congress people that we have met are the smartest people around? The ones most able to tell you how many arms can be cut off in an industrial thresher before that thresher is ruled unsafe under the occupational health and safety standards? Do we really think that, Marjorie Taylor Greene is the best possible person to make that decision? Or do we think that the experts at OSHA are the best possible people to make that decision, right? So what Chevron deference does is that it takes that decision away from the experts, and it fundamentally takes it away from Congress, because Congress does not have the skill the time or the skill to get to the granular level with some of these laws. It takes the decision away from the people, away from Congress, and gives it to the court. The court is the one that wears the crown now. And so many of the cases that we're talking about, whether we're talking about the ATF regulation in the ghost gun case, whether we're talking about various LGBTQ issues happening in the states, so many of the decisions that we used to leave to executive agencies will now be determined by the Supreme Court, which, I will just remind you, none of us get to vote for.
Thank you, Elie. I've heard a lot of administrative law professors explain the impact of the decisions last term. I don't think I've ever heard it quite put this way, and I think this is people need to hear this because they're seemingly technical questions that actually, I think more than anything else the court has done recently, have an enormous impact on people's daily lives, health and safety, and the way that the relationship between the government and the people. And that's a perfect segue to what I want to ask Ari about, which is, I think we're really, we're fortunate to be here with you. You have a unique position as both a legal commentator on MSNBC and a lawyer, and someone who I think, you have a bead on the national discourse about the court and how it intersects with the political discourse. So this is now the third term with these same people on the court. The overall approval rating of the court is extraordinarily low, lower than it's been since people have been keeping track of these things. So I wonder if you can just comment on the stakes of what the Supreme Court has been doing, either last term or you can go back to Dobbs, and how that affects public opinion about the court heading into the election. Has the Supreme Court ever been as front and center on the ballot in a presidential election as it is now?
Thanks for the question. Great to be here with the panel and with all of you. And I see wine in the audience, which is always helpful for the indefinite future, probably. And yes, pardon me for being late. I got dispensation in advance, like when you used to get permission slips at school, because I came straight from work. So great to be with you. I do think big picture, as Elie reminded us, you can get into the details of administrative law and Chevron deference and what agencies are good at and why the world is literally more complicated than it used to be and why scientific and other sort of detailed areas require more than just judicial reasoning, which is why we had agency expertise. And that's one level of interpretation, or you can just say this is a power grab. And Dobbs is a power grab. And the court is extremely confident. We will see whether it was overconfidence about its ability to grab power, wield power in an unelected way, and tell everyone, deal with it. And I don't know whether over time, with everything going on, that will work. I think according to the conservative majority, it works if they completely get away with it. I don't know how many people love a good, old Annie Hall reference. If it bends, it's funny, and if it breaks, it isn't funny. That's what the shitty Alan Alda character used to say. If it breaks, then even by their somewhat cynical standards, it will not have worked. If it doesn't, and they get away with it, then they'll say, well, it was worth it. And so I think that's their approach to various issues, including choice and agency law, which then brings you into the gun case. You can look at that as how friendly are you towards the criminal or illegal use of guns, right? Very low bar. And I think if today's arguments are interpreted correctly, and I think everyone sees it that way, as you were saying, then they took the power to deal with guns, but on this particular issue are not going to be super lax on another loophole for criminals to get guns. But they're the ones, oh, look at this. I mean, I am off air. L'chaim, cheers. Thank you. Was that a 2012, I think? Tannins? I don't know. So the power grab then turns into administering it, and in some cases they may say, especially when it's not as complicated, okay, look, see, we're not being as lax about guns as we were 10 other times, but they've already taken that power, and I expect in other cases they'll use it differently. Does it matter that they're grifting and getting caught in scandal and being overly political through their own acts and the acts of their households and families and then not recusing, that's up to the public. I haven't yet seen evidence, given the dumpster fires that everyone's dealing with, that this is a top issue out in the country in the election. That is to say, the court. I have seen evidence that overruling Roe as an issue that affects people's lives is a big deal. But what I think many people on this panel and in this room might be concerned about, I haven't seen. And then finally, I'll just jump into the case we were I guess we're jumping around, but we were still on this case. I think it's very interesting. I just pulled the law, the Tennessee law, and if you read it, what it claims to be is a law that's trying to protect minors. That's its claim. And if you go to the text, as so many judges like to do, it says it bans healthcare providers from knowingly performing on a minor medical procedures that would enable the minor to identify with or live as, and I'm quoting, a purported identity inconsistent with the minor's sex, or treating, quote, purported discomfort from a discordance between the minor's sex and asserted identity. Then, in its exceptions, which when you read law you have to always look at, it says, but of course, if something is to deal with what medically is a disease or problem, I'm paraphrasing, then you can do it. But then that opens up another problem for them, which, again, apologies if this came up earlier, but you didn't do the case earlier, right? So they say, for purposes of that subdivision, quote, disease does not include gender dysphoria, gender identity disorder, gender incongruence, or any mental condition, disorder, disability, or abnormality. Even if you put aside for a moment the word debates that exist, and whether the DSM is correct, I would just observe that the law kind of collapses on itself, which tells you something about, and I'm not a doctor, so doctors can debate how to classify things. Wanting to be with someone of the same gender used to be classified as a disorder and now is not, and all these things are fluid, to use another popular word. But the fact that the law doesn't stand up on its own, I think, is telling. And then second, and this is where the politics come in, as I understand it, and we have people who spend more time on this than I do, but as I understand it, they used rational basis review and said there's no animus, right? No animus. There's no bias or negativity or hatred motivated by these laws. Bullshit. And again, this is where the courts like to say they're dealing with only these high-minded principles. No, if you look at animus, did anti-gay or anti-trans or anti-Jewish, anti-Semitic animus drive something? That brings you back to the political environment of the time. And there was no such law banning these procedures ever on the books prior to 2020. So I would say that there are some issues if you had, imagine a group of people, whether they're in the legislature or not, who are genuinely concerned about tough debates over minors and age level and how you do these things. I think that's a fair issue in a democracy, and there's going to be some discourse on that. This isn't that. As someone who's both a legal reporter and just a general interest journalist, it's a ton of transphobic, trans-baiting, anti-trans animus that drove all of this. And so even before you get to what might be the more complicated questions, right in the beginning, you have the court finding no animus in a political environment that we're all living through, where you don't need to be a lawyer to understand that. And as I understand it, if they'd found animus, then you have a much more searching, skeptical review of these laws. So I'm very curious how you look at all those issues as an expert, because it seems to me false to find no animus and then go on from there.
Absolutely, and I want to actually jump in because the rationale that they used to find no animus is the Sixth Circuit said that, well, they couldn't be acting with any animus because they only targeted youth. They would have targeted everybody if they had animus. The problem is that they actually did target everybody in so many other laws targeting the trans community in Tennessee. For instance, they passed a bathroom sign law that said, warning, you have to put signs up that say, warning, even though this bathroom says woman, if you allow a trans person in here, it doesn't mean that. You have to put these like orange signs up there, caution signs. Caution, you might approach a trans person in this bathroom. Like there's clearly animus, it's clearly BS. And then you want to talk about protecting kids, They just had a study that came out just this last week in Nature Human Behavior. And this is the first natural experiment because 20 states have passed anti-trans bans, these gender-affirming care bans. And they found out that in those states, suicide went up by up to 73% for transgender youth. So it is not protecting the kids. If anything, the trans youth in these states are currently at higher risk of death.
With guns that the Supreme Court will make it easy for them to
Exactly.
purchase.
So there's a lot to talk about. I think it would be great if we could turn it over to your questions and hear what you'd like to ask the panelists. Oh, okay. Well, I'll just ask, I mean, you know, to pick up on this discussion, there's a long history of, like, one of the questions in the case is, do you get strict scrutiny for these, for you know, laws that target transgender people? And I think most conventional observers of the court think there's very little chance that this 6-3 conservative court is going to do that. But this is an especially cruel law that targets minors and prevents them from getting the treatment that everyone in their life thinks they need. And so there is some history of using rational basis to say, before the court actually takes the step of recognizing a suspect classification, to say this violates even rational basis. And I think some of the advocates, and you know, I think this is the ACLU is pushing for this, that is a way that the challengers could actually win this, eke out a victory. Does anyone see that happening here?
You're doing law, right? You're trying to do law. And the court doesn't do law. That's not what the court is there for, right? They're not interested in, and I deal with this a lot where people will make really good, really involved arguments to get this case over the line, to get that case over the line, without understanding that the Supreme Court doesn't give a goddamn about your legal reasoning. They want the outcomes that they want.
This is the court, though, that decided Bostock, right? And they decided that, you know, transgender people can be victims of sex discrimination in violation of the Civil Rights Act, right?
I think it's because they like that outcome.
And
Right, like I think what we're trying to figure out is just how cruel and evil this current court wants to be towards the trans community, and we don't know the answer to that. So if they don't want to be cruel and evil, then they will do something similar to what you suggested. But if they want to be cruel and evil, they'll do the opposite thing. Acting like, and I guess here's what I'm trying to say. Acting like Neil Gorsuch is sitting in some room, right, with his brandy, and he's like, I really don't know what the right legal answer is. I wonder if it's, like, that's not what he's doing. It's just not. He's already decided whether or not he wants to slam the trans community on this issue, or if he wants to wait for a better one. And then once he makes that decision, I don't know how he's going to decide yet. I haven't heard him talk about it. I will after oral arguments, but I don't know what he's decided yet. But once he makes his decision about which way he wants to slam them this time or next time, that's what's going to motivate everything else that happens, not any of these legal arguments.
Yeah, I agree with everything Elie just said, and I would say also, one of the things I wonder about is the point at which any member of the court who is driving some of these, in my view, horrific decisions, stops being completely insulated from the public effects of that. I mean, we all live in this area, the justices live in this area. I have folks who've run into some of them at the hardware store, et cetera, and they've let loose. And that was not something that happened before, but when you're hovering at whatever the approval rating now is, I'm not sure, around 10%, like worse than Congress, right? You wonder about it, and I think for those of us who watch the court closely, I agree with everything you've said, because basically they're sort of making up the standards as they go. This is how I view it as someone who leads an advocacy organization that focuses on gun violence prevention. We had Heller. That was a terrible decision. It changed how we viewed the Second Amendment from a historic view of it's a collective right to all of a sudden, oh no, it's an individual right. The only distinction there from the next horrible decision that's made by the Roberts Court in Bruin is there was basically a holding pattern across all of the circuit courts for any decision that they rendered to come up and cert being granted. So we were able to hold the line at every public safety law that we cared about, and basically nothing changed in terms of permitting systems, in terms of Brady background checks, any of that post-Heller. Then Bruin happened, okay? And that completely changed the standard of review for any gun law in this country. All of a sudden, the court decided, sua sponte of nothing, we're just gonna take away any balancing of the Second Amendment with public safety rights, which had been the historic interpretation for time immemorial, and we're going to substitute this new standard because it sounds like a really great idea. And that standard is there a historical corollary to this law in 1781 and then in 1865? Let's just use that as the test, and that is the test. And as a result, we have 1,500, approximately, 1,500 pending cases all across this country seeking to overturn every permitting system, every concealed carry law. That is a tsunami. And I don't think this court fully understood when it issued that opinion what it was unleashing, or they would have decided Rahimi different.
Thomas.
They didn't do that.
Thomas understood. But I was just saying, and I just
Thomas,
want
but
to
not
bring
the
on the insight,
rest.
because I was just talking about this with Nan, right, about Roberts, right? If you've seen the reporting post the ridiculous immunity decision, Roberts was allegedly shocked that the immunity decision went down so poorly. He thought it was, people would expect it as good law, and he was surprised by the reaction to it. And I was just saying to Nan, do you realize how deep up the ass of MAGA you have to be surprised at a reaction to the immunity decision? Like, do you realize just how closed off your circle of just people you interact with every day you have to be shocked by the reaction, all right? Because it's like they say in Pulp Fiction, like whatever you thought was gonna happen, you better thought that there was gonna be a reaction to what you did, right? And so for him to not think that there was gonna be a reaction, for him to think that people would just be like, oh, clearly, why shouldn't Trump be a king? That's no problem. What are you doing? And it shows deeply how these people have gotten so into their own bubbles that they're just not interacting with the country as it is, right?
So I would jump in, put it a little differently, and I have Elie on my own program all the time, so I love debating with him. But I would put it slightly differently, and it's more interesting when we get to the fissures, the debate. I think you're absolutely right that on the big cases, it's political, which means they have an outcome and they back it in, which is the opposite of how we were taught in law school, as if it was a mathematical formula and you get the review standard and then you plug in the inputs. That's not what's happening on the big, juicy political cases, obviously. That's why precedent is overturned, right? But I don't go as far as Elie, in my observation, based on my understanding, with all cases. I think there are a ton of boring cases that they don't even hear, and technical cases that they hear and you get these interesting outcomes where they're not doing that. I do feel that in law school it's like this type of very intense, brain bending or brain washing, and then you get out in the real world, and I feel like law school, at least I went to Cornell Law and very happy and not shading them, but my experience was that we were being taught a bunch of rules that the court doesn't actually apply. So I agree with you there, and I think if I were, and nobody's asked me, but if I were asked to go teach a law school course right now about the big cases, I would teach it a lot more like Congress than the court. And I say that as an insult to the current court. That's, I think, what you have to understand. You'd be looking at, why does money matter when you take a political science course about Congress? Why does party affiliation matter? Why do people say one thing in public and then act differently when they have the power to do what they want? That's how I would teach it for a lot of the big cases. I disagree that it's everything. I mean, I'm not going to call that cynical, but I'm going to call that over-inclusive. How do you like that? That's very, very legal. And then the second point I wanted to share is, even with all that said, there's still, what is your theory of social change? Martin Luther King had more impact on federal law than most people who've ever practiced law. And he had a theory of social change, which is, look at all these contradictions. I'm not just going to insult all the people who are in power. I'm not only going to march and criticize them. I am going to build a movement that demands that some of these contradictions be improved upon. That America has a debt it hasn't paid, and we're here to collect on it. And no one's going to help you collect your debt unless you make them. So he also had Malcolm X and SNCC and all these other groups. And I'm not here to give a history lesson to some people who may know more about it than I do or lived through it because I was only born in 1980. But you get what I'm saying. And so there's always an interplay between law, politics, democracy, as long as we keep our democracy. And so I can pick other examples, even with the conservative court. There were basically 3 votes in 2020 from the MAGA side to try to open up mail-in ballots and do gosh knows what, but I don't think it was to leave everything the same, right? I think it was a preordained hack political operation. But there were 3 votes, not 4 to grant cert and not 5 to get a decision. We're all watching this cycle. But those justices' understanding of what is possible, what is in the Overton window, whatever theory of change you want to use, I think will still matter. And so that's where, are you just leaning as far as you can within the powers you have? Courts do overturn precedent. Are you going further to say that we're not going to have the results of the election honored because we found some loophole? And I'm not talking about Florida 2000 where it's debatable. I'm talking about a candidate clearly wins by a state or more, and you come in and steal it. I don't know that that's as far as 5 votes. So I'll hand it back to anyone on the panel to debate it out, but that's where you and everyone comes in, because what's your theory of change, what's allowed, and how will you be heard?
So one question it seems like we're debating is whether law matters, maybe even whether law exists. And, you know, I am a practicing lawyer. I argue cases before the Supreme Court. We have like 3 cases coming up. And so I'm going to have to put myself firmly in the law matters category. In our firm, we like to talk about, people talk about the shadow docket. They talk about, you know, the 5 big cases of the term. But there's also like a law docket. And I think of the law docket as the docket where the legal materials are actually relevant to the decisional process. And there are quite a few of those cases. So law does still matter. And there are still cases that we can win that matter for real people's lives. And, you know, and this court is a court that is different. Its conservative priorities are different from the Supreme Court 5 or 10 years ago, and that can yield different outcomes. So I think, you know, law still matters, at least in my view. It's probably not surprising that a lot of the questions that you all submitted are about what to do about this. So I want to now turn over to the panelists the question of, like, you know, questions about court reform. And the questions here are, what would you like Congress to do to minimize harm from SCOTUS? Do you support adding justices to SCOTUS? Should the president remove justices who have not? Okay, and there are questions about ethics standards. So I'm just going to conflate that all into one question and turn it over to any of the panelists who want to speak. And I think Elie wants to jump in. But
Oh, yeah.
Yeah. Why don't we do a lightning round?
Well, okay, so like in my area of expertise in trans care issues, you know, we are looking at what will be a generational fight. This is going to be a 10 to 20-year fight, we believe, many of us believe, because I don't think a lot of people are super hopeful for the Supreme Court decision on Scrimeti. That being said, you know, there are a lot of extra avenues that we've found and that we've worked in. For instance, there are some state Supreme Courts and some state constitutions that are better than the federal constitution whenever it comes to protection for trans people. My fiance is Representative Zoe Zephyr out of Montana. Many of you may have heard of her. She likes to say that the Montana Constitution is goated because the Montana Constitution has a right to seek health care. And so no matter what the Supreme Court decides on transgender health care, the current law that bans gender-affirming care in Montana is currently blocked, and it will be blocked because of strong precedent there. I also want to add that that precedent happened because, or that the argument happened because just after they passed the gender-affirming care ban in Montana, they then passed another bill that said you have a right to try experimental medication meant to protect access to hydroxychloroquine. The judge looked at that and said, you played yourself because you literally just banned something with the rationale that this is experimental, and then you said you have a right to try experimental medications. So, people are trying to find as many little avenues as possible to go ahead and challenge these laws. Same thing is happening in Ohio right now. And I think that, we chip at it. We nickel and dime it until we get to where we need to be. There's a whole extra way to challenge a lot of the anti-trans bans right now that came out of the Fourth Circuit Court that basically uses the Americans with Disabilities Act to challenge trans bans. That has not actually been used in any of the challenges that are currently pending right now. But what they basically said is that the ADA, whenever they passed the ADA, they specifically excluded gender identity disorder because of the ICD and the mental health care diagnosis thing. However, the diagnosis code has been changed to gender dysphoria. And so that's a whole new avenue that has been successful in the Fourth Circuit right now. I think we'll keep on trying to chip at it until we, find a way in.
I mean, look, you add justices or you do nothing. You add justices or else it's a generation of Christo-fascist takeover of the legal system. I know a lot of people love term limits. Term limits are awesome. Term limits are cool. Term limits are super popular. Politically, term limits are probably unconstitutional. And it's not me you have to convince, right? Because you can convince me that term limits are constitutional. But if you do the current plan, 18-year terms, you have to retire. Who are the 3 justices who have currently served more than 18 years? Oh, that would be Clarence Thomas, John Roberts, and Sam Alito. So you don't got to convince me, you got to convince them that term limits are constitutional. And for my 2, they're still doing law people on the end, I would ask you, do you think you can make a law argument to Clarence Thomas that's like, you gotta leave Clarence? He's gonna be like, okay, I'll just go to my RV now. Like, do you think that's gonna happen? No, that's not gonna happen, right? Because they don't do law. They are going to protect their own position, and they're gonna tell you that term limits are unconstitutional. The reason why court packing is constitutional is because there's nothing the court can do to stop you. Right? Congress passes the law, the Senate passes the law, the president signs it, the president appoints new justices, and then what is John Roberts gonna do? Lock the door when those people show up to work? I mean, John Roberts can do a lot of things, but he can't fight, right? Especially if you're fighting like 4, 5, 6 people who are trying to get in to the door to do their work. So you expand the number of justices on the court to allow you to do all the other reforms you want. You want term limits? Give me 9 justices who agree that term limits are constitutional and then pass your term limits law. Guess what? Now it's legal. You want ethics reform? Give me 9 justices who believe there is not a separation of powers argument against Congress regulating the ethics of the Supreme Court. And then guess what? You get your ethics reform. But you get nothing if you don't add justices to the Supreme Court.
Well, gee, that's really hard to follow. I guess I would just, as someone who worked on the Hill for a long time back in the 90s, so I'm aging myself, I mean, the reality is you need 2 bodies to pass any laws to expand at the federal level the number of people on the court, and then you need a president to sign it. So right now, and I'm cognizant that we're on a C3 sponsored, but just factually speaking, that means what folks are talking about is a trifecta, right? That means you have a Democrat in the White House, you have a Democrats leading the Senate, Democrats leading the House. Right now, the math on that is super tough, okay? It's super tough. And I'm not saying it's not possible because for our organization, our view is everything is on the table because gun violence prevention cannot be accomplished in a material way with this court is our view. So yes, we advocate for expanding the court. We also advocate for Congress passing the Brady law, which 90% of people want to have happen. We advocate for assault weapons bans, and you know what? None of that is necessarily going to happen even with a Democratic Senate because we have something called the filibuster. And even behind the scenes, guys, in the conversations happening with the people who would potentially lead the Senate, if there is a Democratic Senate, which is a big if, they are looking at a very narrow exception to the filibuster, if any at all. And our issue isn't on there, and neither is expanding the court. So I think for us who care about this, we have to understand, for those on the other side, right, as a partisan here, individually speaking, in my individual capacity, as a lifelong Democrat, someone who's raised as a Democrat, my mom ran for office, I understand all of this. Where I think the Democrats have completely screwed up is not understanding the long game, because they have. So for all of us who care about this, who want this to happen, we cannot allow ourselves to be defeated if we don't get what we want with the right people in office after November. Please stay in the long fight. We need you, because for my issue, I have to deal with grieving parents, individuals who got shot walking to school, going to the grocery store. It is absolutely, to me, insane that we're the only industrialized country that has this kind of carnage, and we are. It's the #1 killer of kids. At the same time, our biggest enemy is not the National Rifle Association. Thanks to Tish James, they are really in a bad place, right? It's NSSF, it's Gun Owners of America for sure. Our biggest enemy is hopelessness. And so we have to understand this is a long game. Yes, everything should be on the table, but let's be super realistic that if we can't get everything, it still matters who's on the Fifth Circuit, because that's how all of these cases on our issue are getting to the Supreme Court. So let's make sure we get judges appointed in the federal judgeships. Let's not wait, as some folks have done in the past, who shall remain nameless, and make all of the things a priority. And I'll get off my soapbox and pass the mic.
How about this panel? Strong panelists. Can we talk about your drip for a second? Will you show them the bracelet? Do you guys see this candy cane? Hold up high. You see this candy cane spirited bracelet? I mean, candy corn. I love candy corn. So it's a cool. Can you guys see that in the back? Yeah. It's $1? Okay. It would cost a lot more to buy Clarence Thomas. So, I mean his votes. That's what's for sale. Just the votes. Sorry. Many great points. Donald Rumsfeld said, you don't go to war with the army you want. You go to war, see the wine is, I told you the wine was gonna be a part of the theme tonight. You don't go to war with the army you want, you go to war with the army you have. It was a thoughtful and sensitive sentiment that he shared. It's aged well. My point is, this is the Supreme Court you have, and the main way that you change its outcome is through presidential elections, and everybody understands that, and I still think that is, if you were making a pie chart, I would put that above 90% of the impact. The other big picture ideas are great, they're interesting. I think it's an open question if you start a round of what Professor Balkin calls constitutional hardball, and you start adding to the court what happens, open question, but who knows? Ethics reform, great. The current president and the vice president have endorsed that. Seems like a start. Members of Congress who are passionate about that. You just talked about the appeals court. So all of that is the army you have. The other question is what we're living through, and we'll find out a lot more about that in exactly a month from today. But there are tremendous tremors, concern, backlash, anger from young people to the women's movement to the yawning wealth gap. And so when people like us, everybody remember Talking Heads? People like us? Anybody? No? Yeah? Wrong crowd? When people like us who have law degrees and are in this mode, we talk about it, we talk within a certain frame. There may also be a larger uprising to your question that you raised earlier, which is, does it matter if the court is this unpopular? And what more does it do? And how many more rights does it take away? And how many more elections might it mess with or not? Also open questions. But I am reminded of the late, great Nipsey Hussle, definitely the right crowd now, who said, do you know where I'm going with this? No. He said, I know some people that you probably don't know. I go to some places that you probably can't go. There's pressure built up and it's probably gonna blow. And we have seen a right-wing type of violent set of recriminations from Obama's election to the Trump era. And we'll see what happens a month from now. But there are all sorts of recriminations. And so if we get to a point where things do blow, absolutely the norms and traditions of the Supreme Court may be called into question in many different ways. I would always advocate peacefully and through the formal civic means, but those include protest and direct action and people who may feel that it's time to blow. So all of that goes to, are we talking about within the box of the Senate process and confirmation hearings and vetting, or are we talking about something larger? If they take another one or two fundamental human rights, I mean, as a thought experiment, if they took away some male right, the way they took a female right, I would say as a broad generalization, men have a worse track record of dealing with things through the civic, peaceful process. There's a lot more. You study criminology. I did work in criminal defense. Like, a lot more violent male criminals than female criminals, right? So they take away a couple more rights, you may have things blow. And people who thought they didn't care or were fine with the status quo, as always, find that they are much more concerned when it affects them. So I did want to end on a profoundly dark note. I don't know if you guys have been to a Trump rally recently, but it's even more bananas than that. So I wanted to kind of capture the mood and just give you a real downer. I'm short-term pessimistic. I'm long-term pessimistic. Enjoy the wine. Thanks for having me.
Don't I sound so much more reasonable now? We could just pass a bill. Things are gonna blow. No, we could just pass a bill and add justice. I'm the reasonable one now.
That is the perfect way to end. I was really hoping Ari would drop some lyrics. I was hoping that somehow Elie would be the reasonable one. Thank you so much for this incredible panel. I learned a lot. And I just want to end with a quick plug for the Alliance for Justice, the amazing organization that's hosting this event. The indispensable Nan Erin is here. She's the founder. She founded this organization 45 years ago, and for those who don't know, this is the organization that builds a pipeline of progressive movement lawyers to put them on the bench and works in all the different levers to make sure that it matters who's on the Fifth Circuit, and that's what Alliance for Justice does, is make sure that the right people are in place when there are judicial appointments. And the other thing they do is act as a kind of progressive infrastructure builder for advocacy organizations. In this election cycle, they're making sure that organizations throughout the country can do the advocacy they need to and stay within the law. So it's an indispensable organization, and really proud to support it. I hope some of you will support them financially, because they need your funds as well. Thank you.
One more round of applause for Deepak and our panel. I also want to be sure to thank Amy Ciciora, Maddie DeLone, and others who were very successful in putting this night together on our staff and our board. What I hope you take away from tonight is that while our conversations are rooted in the Constitution and law, the impacts are the safety and the health of our communities. That is what's at stake. So as Deepak mentioned, do not let tonight be the last time that you interact with Alliance for Justice. Follow us on social media. Later this month, on October 22nd, we have first our next holding court conversation, which is a virtual conversation with Renee Bracey Sherman about her new book, Liberating Abortion. And then here in DC, later in the evening, October 22nd, join us for Justice Trivia, where we take over the bar, Stoney's on P Street. Law degree may help, not required, but for a good, fun night of trivia as we look ahead to the important work. Thank you very much again for joining us.